This is a very, very dark time, because it looks like the president has finally violated a direct court order. The Trump administration is claiming that they can deport anyone, including presumably American citizens, without due process, simply by calling them a member of a gang which has been labeled as a terrorist organization, claiming authority from a law from the late 1700s. On March 16, 2025, the Trump administration deported, or more accurately, renditioned over 200 alleged members of the Venezuelan gang Tren de Aragua to El Salvador, despite a federal judge's order to halt such actions. Hundreds of Venezuelans, some seeking asylum, were renditioned away from the country with no due process, no evidence, no hearings, and no judges. And in fact, some were scheduled to have hearings, but were loaded on a plane and deported to prevent that hearing from taking place. Credible reports are already coming in that several of the Venezuelans were not members of any gang and were labeled as such simply because they had one or more tattoos. You'll note, of course, that the deported Venezuelans were not from El Salvador, yet the deported individuals appear to have been transferred to El Salvador's Terrorism Detention Center, which may be acting like an extrajudicial private prison under a $6 million agreement between the United States and El Salvadoran President Nayib Bukele, who calls himself the world's coolest dictator. The administration invoked the 1798 Alien Enemies Act to expedite the deportations, claiming the law is necessary to address the gang's involvement in crimes like kidnapping, extortion, and contract killings. But the deportations proceeded even after federal Judge James Boasberg directed the government to turn around any planes carrying individuals being removed pursuant to Trump's Alien Enemies Proclamation. It appears the Trump administration did not turn the planes around, and one or more planes even took off after the order was given. It appears that the Trump administration is defying a court's order to deport people to a foreign gulag. Trump's actions are an unprecedented challenge to the Constitution and the rule of law. I think this is going to be a historical black mark on this country, where people's clear civil rights were infringed and basically eviscerated for no real benefit. Now, during Trump's appearance at the Department of Justice last week, he announced that he was about to deport people he believed were associates of Venezuelan gangs. Now, some of that could be true, but we don't know because these individuals have not received due process.
That's the Venezuelan gang, the toughest gang, they say, in the world, and the Mexican drug cartels as foreign terrorist organizations. That's a big deal. Nobody wanted to do that. And by the way, we've caught hundreds of them, the Venezuelan gang, which is as bad as it gets, and you'll be reading a lot of stories tomorrow about what we've done with them. And you'll be very impressed, and you'll feel a lot safer too, because they are a vicious group.
On March 15, 2025, President Trump issued a proclamation invoking the Alien Enemies Act of 1798 to expedite the deportations of Venezuelan nationals associated with the criminal organization Tren de Aragua. This group was designated by the Trump administration as a foreign terrorist organization in January 2025, and has been implicated in various criminal activities, including murder, kidnapping, extortion, and trafficking of humans, drugs, and weapons. Now, normally those allegations would be adjudicated in the normal criminal and immigration process. But the proclamation categorized Venezuelan nationals over the age of 14 who are neither U.S. citizens nor lawful permanent residents as, quote, alien enemies, thereby authorizing their expedited removal from the United States. Expedited removal purports to allow immigration officials to quickly deport people without a formal hearing before an immigration judge. Trump's proclamation does not define what it means to be a member of Tren de Aragua, and reports indicate that the administration began deportations even before Trump had issued the proclamation. Now, the Alien Enemies Act is one of the controversial Alien and Sedition Acts that Congress passed in 1798 under President John Adams. These four laws suppressed political opposition and tightened the president's control over immigration. In response to the growing tensions with France, Adams sought more control over newspapers, immigration, and naturalization. The laws quickly became tools for the Federalist Party to target its political adversaries, particularly supporters of Thomas Jefferson and the Democratic Republicans. The Alien Enemies Act purported to allow the president to detain or deport immigrants from nations with which the U.S. was at war. During World War II, President Franklin D. Roosevelt invoked the act to justify the internment of enemy aliens, specifically Japanese, German, and Italian nationals residing in the United States. And the act is still on the books today. You can take a look at the text codified at 50 U.S.C. 21. Quote, whenever there is a declared war between the United States and any foreign national or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign national or government, and the president makes public proclamation of the event, all native citizens, denizens, or subjects of the hostile nation or government, being of the age of 14 years and upward, shall be within the United States, and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. Trump's proclamation tracks the statute by stating that the U.S. would deport any member of Tren de Aragua who is over the age of 14 and does not have a green card. Now, according to the text, the president can only assert these sweeping powers when the United States is in a declared war against a nation or government, or when a foreign national or government is invading or attempting to invade the United States. Until now, the government has only used the statute during 3 actual wars: the War of 1812, World War I, and World War II. Trump's claim that we are at war with Venezuela or a Venezuelan gang is an unprecedented power grab by a president in peacetime. So on March 15th, 5 Venezuelan nationals detained in U.S. immigration facilities challenged their imminent deportation. They filed a lawsuit before Trump had issued his proclamation. They argued that the use of the act to justify their removal was unconstitutional because historically the statute has only been applied during formal wars, not in response to non-state actors like criminal organizations. The plaintiffs also argued that while the gang may pose security concerns, it's not an entity comparable to a hostile foreign power, and therefore does not meet the legal criteria necessary to trigger the Alien Enemies Act provisions. The plaintiffs emphasized that Trump's proclamation allows for the immediate deportation of Venezuelan nationals without access to legal review or due process protections. And they claim that this violates the Fifth Amendment's Due Process Clause, which guarantees that non-citizens have the right to challenge government actions affecting their liberty. Based on what I'm seeing, I worry that this case was chosen on purpose as a test case for defying a court order. News reporting is credulously stating that the deportees are Venezuelan gang members, and while that may be true for some of them, no evidence has been presented of that fact. And based on other reporting, it's definitely not true for some of them. Additionally, the plaintiffs argued that the government has engaged in tactical relocations to expedite their removals. They assert that detained Venezuelan immigrants were transferred to Texas so they could be swiftly deported before they had the chance to file legal challenges. On what basis can you send Venezuelan immigrants to El Salvador? I have no idea. I've not seen any credible legal defense for renditioning hundreds of Venezuelans to a for-profit prison in El Salvador where they're going to do hard labor. My hunch is that there's probably a reason why this has never been done before. These, again, Venezuelans were effectively sold into slave labor in a country they might not have ever been to before. And if the government has proof that the individuals were members of Tren de Aragua, then why not go through the traditional removal process, affording them the opportunity to present evidence to the contrary? And in fact, some of the people who were deported had hearings already scheduled where the government could have made their case. Now, we recently covered the wide discretion that immigration courts have in the context of Mahmoud Khalil, and it's likely that many of these deportees would have been deported through the regular process. But the Trump executive order circumvents even the modicum of due process that would have been afforded under regular immigration procedures. This should concern everyone because since there is no due process, anyone, including American citizens, could simply be labeled an undocumented gang member, loaded on a plane, and renditioned to a seemingly random foreign country's prison. And at least one of the deportees claims, and you can take it with whatever grain of salt that you want, he was seeking asylum in the US because he was LGBT and was specifically fleeing gang violence in Venezuela. It now appears that a large number of the deportees had no criminal background, but the Trump administration says that these people are terrorists, and worse, the government says that the lack of evidence about their activities actually proves how much they are terrorists. Quote, "While it is true that many of the TDA members removed under the AEA do not have criminal records in the United States, that is because they have only been in the United States for a short period of time. The lack of criminal record does not indicate they pose a limited threat. In fact, based upon their association with TDA, the lack of specific information about each individual actually highlights the risk they pose. It demonstrates that they are terrorists with regard to whom we lack a complete profile." So for all these reasons, the plaintiffs asked a federal court in Washington, D.C. for a temporary restraining order to halt these removals while they were in the process of happening. Now, if you're going to defy a federal court judge, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, the plaintiffs filed their lawsuit on Saturday morning, which is already unusual. And later that same day, the chief judge for the District of D.C., James Boasberg, granted a narrow TRO, temporarily preventing the removal of the individual plaintiffs for 14 days. The judge determined that immediate deportations would irreparably harm the plaintiffs by depriving them of due process rights before they had an opportunity to challenge the government's actions. And the judge's order happened before Trump had officially issued his proclamation and before the government had a chance to respond. But the judge felt he had to act because if the deportations went through, the plaintiffs would suffer irreparable harm. They would be jailed in a foreign country. Now, the initial TRO was limited in scope, applying only to the 5 named plaintiffs in the case. The judge ordered the government to halt their removal while the court reviewed the legal merits of the administration's use of the Alien Enemies Act. But shortly before the 5 p.m. on a weekend emergency hearing, Trump finally issued the proclamation the plaintiffs had anticipated. Now, the timing of the proclamation raises another legal issue. Was there a secret order authorizing the removal of the detainees before Saturday afternoon? In the week leading up to the deportation, some of the detainees missed deportation hearings because the government had moved them in preparation for these unlawful deportations. And during the hearing, ACLU lawyer LegalEagle asserted that at least 2 planes containing the Venezuelans were already taking off. So the parties took a short break so that the DOJ's main lawyer arguing the case, Deputy Assistant Attorney General Drew Ensign, could consult with his clients. He confirmed that the flights were in the air. Now, all the hearings that we're going to talk about were public in the sense that lawyers could call in, but people were not allowed to record them, so I'm relying on the accounts of the lawyers that actually called in. And according to civil rights lawyer Remy Green, Judge Boasberg agreed with the plaintiffs that the act did not apply, saying, quote, "Invasion means war. This also means the government, not gangs. The Alien Enemies Act doesn't work." Judge Boasberg also warned the government to follow his order, quote, "DOJ, you shall inform your client of this immediately. Any plane containing these folks cannot take off. If it's in the air, it must turn around." And plaintiffs who had access to the official transcript of the hearing later confirmed the exchange. And with respect to the original 5 plaintiffs, the judge said, quote, "I would assume that means that they, the 5 named plaintiffs, are either not on the planes or that they will not be removed from the planes and will be brought back once the planes land in El Salvador. Is that fair?" Now, these exchanges are really important because they show that the judge was clear about the parameters of his order. When the court winds up deciding whether to hold the government in civil contempt of court, which we'll talk about later, the plaintiffs will have to prove that the orders were clear and that there wasn't any room for interpretation. After the hearing, Judge Boasberg explained the TRO to cover all Venezuelan nationals at risk of removal. Additionally, he certified the case as a class action, broadening the protections beyond just the individual plaintiffs. The government immediately appealed the TRO, and as we've discussed, TROs are generally not appealable, but, YOLO. But that wasn't all the government did, because despite the court's order, Trump continued the deportations. The government officials argued that individuals who were already in transit when the TRO was issued, such as those on deportation flights over international waters, were outside the jurisdiction of the court. Plaintiffs filed a response explaining, quote, "Whether or not the planes had cleared U.S. territory, the U.S. retained custody at least until the planes landed and the individuals were turned over to foreign governments." Again, just so we're clear, if planes have already landed and discharged their occupants, aside from the 5 plaintiffs I enjoined earlier, then this order, I don't have jurisdiction to require their return. Plaintiffs filed a response explaining, quote, "Whether or not the planes had cleared U.S. territory, the U.S. retained custody at least until the planes landed and the individuals were turned over to foreign governments." And the court could not have been clearer that it was concerned with losing jurisdiction and authority to order the individuals returned if they were handed over to foreign governments, not with whether the planes had cleared U.S. territory or had even landed in another country. Now, there's generally no "I'm traveling" exception to court orders. You're either within the court's jurisdiction or you aren't. And I don't want to get off on a tangent about courts of law versus courts of equity, but here the court was exercising its equity powers, but about 500 years of jurisprudence between America and England show that the court's equity jurisdiction extends beyond the territorial borders of the country. And so long as the defendant is within the court's jurisdiction, you can command it to do things that are outside of that particular country. The judge set hearing for 2 days later at 5 p.m. on Monday. And he asked the administration to prepare answers to questions such as whether any flight with individuals subject to the proclamation took off after either the court's written or oral orders were issued. Now, 1 hour before the 5 p.m. hearing, the DOJ filed a notice telling the court that it should cancel the hearing, quote, "because there has been no violation of the court's orders and because the government is not prepared to disclose any further national security or operational security details." This is brazenly inappropriate, and the judge immediately rejected the administration's attempt to get out of the hearing. And in the DOJ's filing, it argued that the court's orders usurped the president's authority as commander-in-chief. It characterized the judge's injunction as oral and therefore unenforceable. That's not how things work, but they argued, quote, "Contrary to plaintiff's assertion, the oral directive is not enforceable as an injunction. That principle holds especially true when the court does issue a written order, but phrases it more narrowly. In that event, the written order controls." Now, you might be wondering, how is the written order narrower than the oral one? Well, it used the word removing, which the government says does not apply to people who were past tense removed. The Trump administration said, quote, "As to any flights that were already outside the U.S. territory and airspace, anyone aboard had already been removed within the meaning of the Alien Enemies Act and the court's order, and therefore were not covered by the order." Now, this is an absurd claim in every respect, and it very well may lead to sanctions. Oral orders carry the same legal weight as written ones, and in this case, the judge issued a written order reinforcing his oral directive. So Trump's argument boils down to this: the government ignored the oral order and deported the detainees, and now the written order doesn't apply because the deportations have already happened. It's a circular defense, with Trump justifying defiance of one order as a reason to disregard the next, and is exactly the kind of BS that a court in equity is likely to take to task. Now, before the hearing, the DOJ also sent a bizarre letter to the DC Circuit, the Court of Appeals, demanding that the case be reassigned because Judge Boasberg is biased. Quote, "The government cannot and will not be forced to answer sensitive questions of national security and foreign relations in a rushed posture without ordering briefing and a showing that these questions are somehow material to a live issue." He's a Yale law grad who started as a prosecutor in the U.S. Attorney's Office for D.C. As a judge, he served on the Alien Terrorist Removal Court and the Foreign Intelligence Surveillance Court, so he's not someone who's likely to take a claim of national security lightly. And he also once ruled against plaintiffs who wanted Trump's tax return, so it's not as if he has some kind of axe to grind against Trump in particular. The government is claiming they cannot provide details on national security grounds, but the claims of national security are at odds with the public displays that they have made. The White House posted propaganda videos of the immigrants landing in El Salvador, and the flights were public and many people tracked them in real time. El Salvador's Bukele posted a story about the TRO, and said, quote, "Oopsie, too late, laughing emoji." And Secretary of State Marco Rubio retweeted that. But it's very clear that the government was trying his patience. At the Monday, March 17th hearing, the government refused to answer the judge's 4 questions that he asked. First of all, the lawyers would not confirm whether the original 5 plaintiffs were still in the US or whether they had been deported. The lawyers, who did not include the original arguing attorney, Mr. Ensign, said that they were only authorized to say that the flights which took place after the court's first order were not subject to the court's ruling, which could mean that none of the 5 plaintiffs were on those flights, but we don't know for sure. Judge Boasberg asked the government why they couldn't share the information in camera, meaning in private, and the lawyers said they cannot share why they cannot share. That's ridiculous. That's not how that works. Judge Boasberg explained that he reviews classified information all the time. According to immigration lawyer Aaron Reichland-Melnick, who listened to the hearing, Boasberg cited case law saying that the government is required to actually provide a clear reason before refusing to provide him classified or national security information. He asked if the DOJ can provide in writing tomorrow by noon what their position is communicating the info to him. And that's definitely correct. If you refuse to give a federal judge that information, you have to explain why. Boasberg only mentioned contempt of court 1 time, but the point of the hearing was to gather facts to determine whether he should find the government in contempt. The DOJ lawyers argued that the judge's short written order, issued 40 minutes after the initial oral hearing, superseded anything that he said orally. And the judges claimed they acted in good faith in only viewing the written order as binding. According to Melnick, the lawyers argued that because the judge's written order didn't include every word he spoke in court, they believed they could simply ignore what he said. The judge then apparently said, quote, "So when I said, Mr. Ensign, you should inform your clients immediately, however that's accomplished, whether it means turning around to plane, etc., you need to make sure this is complied with immediately. You're telling me your first argument is that when I said those things, because it wasn't in a minute order, you didn't have to comply. That's your argument? You're telling me that very clear point. You're saying that you felt that you could disregard it because it wasn't in the written order. That's your first argument." And the government's lawyer responded, quote, "I'm stating what the position of the United States is." Judge Boasberg, like the rest of us, was incredulous. He said, quote, "You knew in the morning that there would be a hearing at 5 p.m. So any planes you were putting in the air, you knew you had that hearing coming. So you're saying that because any minute order was pithier, that's a heck of a stretch, I think." Now, any federal practitioner knows that oral orders are binding, and if they didn't think they had to comply with it, then why didn't they just speak up during the actual hearing when the judge made the ruling? Now, personally, I would rather commit ritual seppuku than make this particular argument, but the DOJ then pivoted to its next argument, that once the flights were over international waters, the judge lost jurisdiction. But Boasberg said, accurately, the equitable power of the United States courts is not so limited, and it's pretty clear that even if the enjoined acts were outside the territory of the United States, the government couldn't violate them. He asked what argument they had proving that a court's ability to rule in equity, quote, stops at the country's borders. The government's lawyers responded that it was pretty simple. The government physically removed people, so the court no longer had jurisdiction. But that would be an incredible claim, because if Trump can defeat a court's jurisdiction by ignoring a court's order and removing people from the court's jurisdiction, then there's really no such thing as law. When Judge Boasberg pressed the DOJ for more information, a lawyer said, quote, "When the planes are in the sky and there is sensitive national security, that's not a call that can be made by a judge." They made one more argument that the president has inherent authority to move military forces, but of course these were not military flights. Judge Boasberg set a hearing for the next day and demanded that the DOJ provide information related to questions such as how many planes departed the United States at any time on Saturday, carrying people being deported solely on the basis of the proclamation, how many people in the category were on those planes, what foreign countries did those planes land in, what time did the planes leave the US, etc., etc. Now, many people have pointed out many constitutional infirmities with the Alien Enemies Act. Just off the top of my head, it runs afoul of the Fifth Amendment's right to due process. There is discrimination based on nationality, which is a protected class, and of course it violates the right against indefinite civil detention. Japanese internment was of course a black spot on this country's history, and the Korematsu case, which approved of Japanese internment, was already mostly repealed by Trump versus Hawaii. So one would assume the Supreme Court, including this Supreme Court, would find the Alien Enemies Act to be unconstitutional. But that's not a given, so by its terms, does the Alien Enemies Act even apply to the Venezuelans under these circumstances? Well, first of all, the US is not at war with any other country, so why would the act apply to Venezuelans now? Well, the government has this one weird trick. Tren de Aragua and the Venezuelan government are one and the same, they claim. Trump's proclamation says Venezuela is, quote, a hybrid criminal state. Evidence irrefutably demonstrates that Tren de Aragua has invaded the United States and continues to invade, attempt to invade, and threaten to invade the country, perpetrated irregular warfare within the country, and used drug trafficking as a weapon against our citizens. The government argues, quote, given how significantly Tren de Aragua has become intertwined in the fabric of Venezuela's state structures, it is a de facto arm of the Maduro regime. Now that seems factually inaccurate, but it also seems legally inaccurate. Number one, only Congress has the power to declare war based on Article 1 of the Constitution. And the plain text of the Alien Enemies Act doesn't seem to support the conclusion that the US is at war. But the government says that the president, as commander-in-chief, is the one who gets to decide when America is officially at war. The Supreme Court has considered the parameters of war in the context of two occasions, both in the aftermath of World War II. In 1948, the Supreme Court heard an appeal from William Ledecky, a German who was classified as an alien enemy and was subject to deportation. By the time the government moved to deport Ledecky, World War II had been over for 8 months. And writing for the majority, Justice Felix Frankfurter argued that despite Germany's defeat, the state of hostilities persisted. Quote, war does not cease with a ceasefire order, and the power to be exercised by the president, such as that conferred by the Act of 1798, is a process which begins when the war is declared, but is not exhausted when the shooting stops. Thus, Frankfurter emphasized that the president had the authority to determine whether individuals who were considered a security risk during the war remained a threat. And Frankfurter stated, quote, it is not for us to question a belief by the president that enemy aliens who were justifiably deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict, which is characteristic of a state of war, even when the guns are silent, but the peace of peace has not come. And the court's decision was also grounded in the belief that the Alien Enemy Act precluded judicial review of removal orders. In a dissenting opinion, Justice Hugo Black and 3 other justices pointed out that Ledecky was a legally admitted resident and should be afforded due process rights. Black argued that the Alien Enemies Act only applied when an individual could assist a foreign government, and with the Allied victory, Germany no longer had a government Ledecky could assist. And in the case of United States ex rel Geolayers versus Carusi, the Supreme Court ruled that a German national who had been classified as an enemy alien held in custody following his arrest could not be detained indefinitely. The court decided the war with Germany officially ended in 1951 with the joint resolution to terminate the state of war between the United States and the government of Germany. And Ledecky arguably doesn't stand for the proposition that only the president gets to say when America is at war. As Ledecky and the Geolayers cases acknowledge, World War II began and ended with a determination by Congress, not the president. But now Trump has an argument for that as well. The political question doctrine makes the case unreviewable. The political question doctrine is a principle of constitutional law that holds that certain issues are beyond the jurisdiction of the courts because they are best handled by the political branches. And when courts determine that an issue is a political question, they decline to hear the case, reasoning that the Constitution entrusts the matter to elected officials rather than the judiciary. And here the government claims that whether the US is at war or under invasion is a political question that is decided by the president. Trump argues that the TRO undermines Trump's, quote, inherent Article 2 authority to repel such an invasion and conduct foreign affairs. And the government asserts that, quote, federal courts have consistently held that the determination by the executive of whether there is an invasion is a non-justiciable political question. On the other side of the fence, the Supreme Court's position has long been that judicial review is available to immigrants detained under the act. For example, in United States versus Thomas Williams, where Chief Justice Marshall, sitting as a circuit judge, granted a writ of habeas corpus, releasing a British citizen detained during the War of 1812. And the second part of the statute gives the president power to, quote, establish any other regulations necessary for removal, which suggests that some judicial review is cognizable. And the Ledecky case does not say that the president's power to establish when the US is at war is unlimited. And during World War II, the courts decided hundreds of cases involving the Alien Enemy Act, and the courts provided some meaningful review to the question that triggered the statute, whether the detainees had connections with countries on which America had declared war. If they did, then the government could decide what to do with them. But if the courts can decide whether a person is connected to those countries, then it would seem like they also have the power to decide the other statutory predicate, whether the US is at war or under an invasion from a foreign country or government. Either way, you'd think the detainees would have some modicum of due process rights. But what about the statute's use of the word invasion? Well, Texas challenged Biden's handling of immigration by arguing that illegal migration and drug smuggling constitute an invasion under Article 1, Section 10, Clause 3 of the Constitution, which allows states to engage in war if, quote, actually invaded or facing imminent danger. Using this argument, Texas attempted to justify policies like detaining and deporting undocumented immigrants, as well as placing barriers in the Rio Grande, despite federal law preempting state action in immigration enforcement. Arguably, this interpretation was inconsistent with the Constitution's text and original meaning. The founders seemed to intend the term invasion to refer to organized armed attacks, not migration or smuggling. James Madison, in his report of 1800, explicitly defined invasion as an operation of war, and the Constitution's Guarantee Clause, which ensures federal protection against invasion and domestic violence, further supports this reading. Domestic violence historically referred to rebellions against state governments, not modern interpersonal violence. And a legal interpretation doctrine called nocitur a suicis, a word is known by its context, reinforces that invasion should be understood alongside terms like war and domestic violence, which imply force or conflict. If Texas's interpretation were accepted, it could distort constitutional war powers and open the door for states to claim emergency military authority over broad issues unrelated to armed conflict. There's also a fairly robust body of law developed during the Bush administration's war on terror that indicates the courts do not completely defer to the president about when the US is actively at war. The Military Commissions Act of 2006 stripped Guantanamo detainees of the ability to file habeas corpus petitions in US courts, and in 2008, the Supreme Court reaffirmed the constitutional rights of detainees at Guantanamo to challenge their detention in federal court through habeas corpus. The Supreme Court ruled that the MCA provision was unconstitutional because it did not provide an adequate alternative process for detainees to challenge their imprisonment. The ruling established that constitutional protections apply to detainees held by the US government, even in overseas military facilities. That was a 5-4 decision written by now retired Justice Anthony Kennedy, though Justice Roberts wrote a dissenting opinion. And there were many cases during the war on terror where the lower courts scrutinized whether detainees were part of al-Qaeda. And based on that precedent, the courts should have a role in determining whether someone is a member of Tren de Aragua. And another major difference is that the war on terror cases involved detainees who had never set foot on US soil, whereas the Venezuelan deportees arguably have more rights since they were living in the United States. Now, the judge asked the government to file a response under seal answering 5 questions, but the Trump administration filed a motion to stay the order, asserting that the government does not need to answer the questions, it can't answer them on such a tight timeline, and the questions jeopardize national security. Now, the administration claims that revealing this information would have a catastrophic impact on US foreign policy, and it is considering invoking the state secrets privilege. Quote, even addressing the questions in an ex parte submission would result in an immediate flood of media inquiries and demands for the information, subjecting the diplomatic relationships at issue to unacceptable uncertainty about how the court will address those demands. And I will remind you that an ex parte in-camera submission is seen only by the court. And frankly, there should be media questions about this case. Now, as for the alleged threat to the relationship between the US and other countries, the judge simply asked for the information about when the flights left, landed, and who was on them. And Rubio and Bukele have not been shy about the budding relationship between the US and El Salvador. A month ago, they were both at Bukele's residence, and the State Department's public press release about their meeting notes said that he agreed to take custody of members of Tren de Aragua and MS-13 and, quote, criminal migrants from any country. Rubio and Bukele made an agreement publicly for El Salvador to take incarcerated Americans, quote, and in an extraordinary gesture never before extended by any country, President Bukele offered to house in his jails dangerous American criminals, including US citizens and legal residents. And of course, Bukele and Rubio tweeted about this affair while it was happening in real time. The government even released footage of masked men shaving the detainees' heads, then whisking the detainees out of prison and onto planes. The deportees did not arrive in El Salvador under the cover of darkness. The media was present, and when the planes landed, the governments of the 2 countries celebrated. The Trump administration literally made a deportation hype video. But Judge Boasberg gave the Trump administration another 24 hours to file the government's response. The judge noted that, quote, the government's motion is the first time it has suggested that disclosing the information requested by the court could amount to the release of state secrets. To date, in fact, the government has made no claim that the information at issue is even classified. The essence of the judge's order is that he wants to give the government another chance to decide if they really want to invoke the state secrets or other privilege, and he also may be appeal-proofing all of his decisions. We'll see. And fair or not, government litigants usually get multiple chances to comply with court orders. But still, for the rule of law to hold up, at some point judges are going to have to get serious about contempt and other measures. In the meantime, President Trump said that Judge Boasberg should be impeached. This triggered a response from Chief Justice John Roberts, who said, quote, for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning judicial decision. The normal appellate process exists for that purpose. Notwithstanding, it is extraordinary for the sitting Chief Justice of the Supreme Court to weigh in on statements made about the judiciary in basically real time. But in a notice signed by Attorney General Pam Bondi, the Justice Department said it would not answer further questions on the flights. Quote, the government maintains that there is no justification to order the provision of additional information, and that doing so would be inappropriate because even accepting plaintiff's account of the facts, there was no violation of the court's written order since relevant flights left U.S. airspace, and so their occupants were removed before the order issued, and the court's earlier oral statements were not independently enforceable as injunctions. Additionally, Robert Cerna, acting Field Office Director for Enforcement and Removal Operations at U.S. Immigration and Customs Enforcement, stated in a signed court declaration that the immigrants on a 3rd deportation flight following Saturday's restraining order were not removed under the Alien Enemies Act, but under Title VIII, a separate final removal authority. Now, how this could be legally possible is charitably unclear. He said, quote, to avoid any doubt, no one on any flight departing the United States after 7:25 p.m. EDT on March 15, 2025 was removed solely on the basis of the proclamation at issue. You'll recall that Judge Boasberg issued his temporary restraining order at 6:48 p.m. Eastern, while court records show that one deportation flight landed in Honduras at 7:36 p.m. and another in El Salvador at 8:02 p.m. Cerna also clarified that although President Trump signed the proclamation invoking the wartime law on Friday, ICE understood it to take effect only after the White House published it Saturday afternoon. He added that approximately 258 additional immigrants fall within the proclamation's scope, with 54 of them already in detention. And not surprisingly, the Trump administration has already appealed the temporary restraining order to the DC Circuit Court of Appeals, which normally isn't a thing you can do. We've talked about that before, but written briefings are due on Wednesday, and the panel's not great for the plaintiffs. It includes Justin Walker, who is about as much of a Trump ideologue as they come. But the administration may be relying on the optics and assuming that people are not going to want to go to bat for putative gang members and terrorists. Now, these are unprecedented times, but taking a moment to increase your online privacy is one way to bring greater peace of mind. Luckily, there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni, because the amount of personal and private data that circulates out there is truly horrifying. Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. And if those data brokers resist, Incogni will take care of that too, because Incogni fights back. And right now you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. Now, data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all of this information. And it also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of sensitive data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it again. So Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle at checkout. So click on the link below for a 60% off discount for Incogni. And after that, click on this link over here for more LegalEagle, or I'll see you in court.